YouTube feed up. It's working. All right, let's try one more time. We'll take it from the top. Mr. Sears, can you hear me?
Yes, Your Honor, I can.
Great. And you represent Ms. Smith?
That's correct.
All right. And Ms. Gibson, you can hear me?
Yes.
And you represent Ms. Montgomery, who it looks like is joining us today?
Yes.
Okay, great. And Mr. Sears, of course, your client is free to join either directly like this, or she can follow along on the YouTube feed, which is live now. If she doesn't want to be here in court, but attendance is not required for a hearing on a motion for summary judgment. So we're going to get going. This is 20cv334379. It is Jolene Smith versus Shaquille Montgomery. And I want to share with you all my limited understanding of what the case is about. I'm not the subject matter expert. That would be Ms. Gibson and Mr. Sears. But what we're here on is a motion for summary judgment that Mr. Sears has filed concerning counterclaims that Ms. Gibson brought on behalf of Ms. Montgomery. And as I understand the basic dispute, Ms. Smith, who is Ms. Montgomery's mother, Ms. Smith and Ms. Montgomery jointly own a piece of property. And they were joint tenants with right of survivorship. And at some point, Ms. Smith conveyed her interest to another daughter, Ms. Berry. And Ms. Berry conveyed that back to Ms. Smith. And Ms. Smith is interested in effecting a statutory partition, basically sell the place or buy me out. Ms. Montgomery has filed some counterclaims, is seeking to quiet title, alleging slander of title, fraud, etc. And Mr. Sears has filed this motion saying, Judge, you ought to grant Ms. Smith summary judgment as to the counterclaims, and we ought to move forward solely on the statutory partition piece. And I know there are many nuances to it, and Mr. Sears and Ms. Gibson will get into those. But Mr. Sears, in terms of an overarching view of what we're working through, is anything you want to add to that or clear up, saying, Judge, actually it's a son, it's not a daughter?
No, Your Honor, I think you've stated it well.
Okay. Ms. Gibson, anything you want to add before we get into this?
No, Your Honor, I agree with your rendition of the overview.
Okay, great. And it doesn't bind anyone. You know, the facts are going to be what the facts are. It's just helpful for me to know that I'm at least approaching the same case you guys are approaching. So, Mr. Sears, you can get started. You filed the motion, you're the movant. And if you want to make argument, you can do that. And then I'm happy to hear from Ms. Gibson, and then I'll give you any last rebuttal you might have, Mr. Sears, if there's something that comes up in Ms. Gibson's presentation. And Ms. Gibson, I've got the magic binder. Thanks for dropping that off. It's got a bunch of exhibits that I suspect Mr. Sears will be referring to as well, maybe not by the same number, but it starts with the petition and the summary judgment motion. We've got some transcripts of depositions in there, et cetera. So I've got those in front of me. Mr. Sears.
Yes, Your Honor, thank you. Again, this is Nick Sears on behalf of petitioner Jolene Smith. You've already kind of given a good bird's eye view of the case, and just to kind of maybe put some dates and some numbers to facts of the case of what's happened is back in June of 2006, Ms. Smith and Ms. Montgomery purchased this piece of property jointly, as Your Honor noted, with joint tenancy with right of survivorship. Obviously, right of survivorship means that they just jointly own this property, and if one of them dies, there's no need to probate this property. There's no need to do anything else. It just, by operation of law, automatically becomes solely owned by the other person on it. And they owned this property since 2006, and initially they had some renters in there, but at some point in 2012-ish, Miss Montgomery moved into the property and she's been living there ever since. In 2019, obviously with Miss Smith is aging, she's trying to think about money she's going to live off of as she gets older. And then with the housing market being what it is, as we are probably all aware, booming through the roof, the idea is let's go ahead and sell this property. A disagreement arose between the two of them of what to do with the property. Miss Montgomery's living there. She doesn't want to sell. Miss Smith is not living there, and she does. And so she comes to me. Idea is let's partition the property, but there's some very clear Georgia case law on point that you cannot partition a joint tenancy with right of survivorship. It only applies to tenancies in common. And so in December 6th of 2019, Miss Smith, as Your Honor noted, conveyed the property via quitclaim deed to her daughter, who shortly thereafter conveyed it back to her. And by operation of law, as we'll get into in a moment, that severs the joint tenancy with right of survivorship, makes them tenants in common. And on that basis, we brought the partition action saying they're now tenants in common. And that's sort of how we get here. We filed a partition action, and in response, Miss Montgomery filed 5 counterclaims, 2 flavors of quiet title kind of based on the same argument, one against the world and one against Miss Smith individually, personally. One counterclaim for slander of title, 1 counterclaim for fraud, and then a kind of 3 different theories of why she should get her attorney's fees at the end.
Why she should get what?
Attorney's fees and expenses of litigation. At the end is count 5.
Yep.
So just to sort of go through it, I would say this is luckily one of those rare cases where there's some very clear Georgia Supreme Court case law directly on point for several of these issues. The kind of the first piece to sort of think about in this, I think, is more of a global question that didn't become apparent to me until I read Ms. Gibson's response brief to the motion for summary judgment, that essentially they're saying, based on some of the stuff that's said in the deposition of what maybe Ms. Berry and Ms. Smith, did they have this subjective intent to permanently quitclaim the property away from Ms. Smith and into Ms. Berry, and then Ms. Berry permanently meant to send it back, and maybe there's something wrong with that, maybe they didn't fully intend it, and so therefore this conveyance and this conveyance back are invalid, and they should just be invalidated by the court, and Ms. Smith and Ms. Berry will just go back to being joint tenants with right of survivorship, and the partition action fails. It's essentially what the quiet title and really kind of what most of their argument in this case boils down to.
You've been saying Ms. Berry a few times. Do you mean Ms. Montgomery? I just want to make sure, because of course there are allegations that maybe Ms. Berry should be the other co-tenant because Ms. Smith quitclaimed to her. And as I understand the dispute, it's between Ms. Smith and Ms. Montgomery, and Ms. Berry could be characterized, I don't mean this in a pejorative way at all, but a straw person. She held title for 20 minutes, it may have been longer, it may have been shorter, but basically the quitclaim or the transfer cycled right back to Ms. Smith to effect the dissolution of the joint tenancy. So then they became tenants in common, so that then your client, Mr. Sears, would have the ability to seek a statutory partition. And I should say up front, I don't see anything sinister in that. And it sure looks like the Supreme Court has said you can do that. So I don't know that there was any foul play in that occurring. But I just want to be sure, when you're saying Ms. Berry in what you were just sharing, you meant Ms. Montgomery.
I believe that is correct. If I ever refer to Miss Berry as being previously a joint tenant of right of survivorship, I mean Miss Montgomery, because Miss Berry has never been a joint tenant with right of survivorship on this. In keeping the names of the daughters straight and having referred to them back and forth for a lot, I may get them confused, so I apologize for that.
Okay.
But the global issue here, and this is we cite to all the basic statutes in the case law in the reply brief, is that whenever it comes to a written instrument that's been filed in the property records relating to ownership of land and title to land, the instrument controls. You can't bring in parole contemporaneous evidence to vary the terms of the instrument. And that's essentially what Ms. Montgomery is trying to do here. all these citations to depositions and these sort of the implication of, well, this happened too fast, and Miss Berry, and I do mean Miss Berry in this situation, Miss Berry never made any payments on the mortgage or toward anything. She didn't really, truly, in her heart of heart, own it. All of that, it's all been addressed by the Supreme Court as essentially irrelevant. The court in Reed versus McConaughey says we just look at the language of the instrument. I think that makes sense given the nature of our property laws in this country, where we're often looking back at deeds that are many decades, possibly even a century older, and trying, if it were the rule that you could attack the ownership and the title of the property by decades later going back and snipping at what someone's internal heart of heart intention might have been, it would kind of wreak havoc. And so the court in Reed versus McConaughey has said pretty clearly, look, the statute says lifetime transfer. That's how you sever. If you make a lifetime transfer while you are a joint tenant with right of survivorship, you have severed that joint tenancy. And we aren't going to go and try to guess at what someone might have subjectively intended at the time. We just look at the language of the instrument and whether there are any carve outs or caveats or anything like that in the quitclaim deed or warranty deed or wherever the instrument may be. We just look and see if there's any sort of contingency or a reservation or some sort of reservation of interest in the actual quitclaim deed itself. And if there aren't, it is a lifetime transfer. It doesn't matter if it immediately comes back or what the case may be. And so I think based on that, the attempt that Ms. Montgomery has done in her response brief of going through the depositions and talking about what they might have subjectively intended, I just don't think it does anything for them. I think just as a matter of law, the instrument controls. So I think that's a global issue whenever it comes to any argument from their side that the deeds are invalidated as a result of something said in a deposition. That I don't think that carries any water, and I think it fails. The other thing to remember here is this was a transfer between Miss Smith and Miss Berry. And again, I do mean Miss Berry. And then a transfer from Miss Berry to Miss Smith. They're the only parties to that transaction. Neither one of them is denying what happened. Neither one of them is saying it wasn't really transferred to me. I didn't really own it. They actually say, I think, Miss Berry even says, yeah, I was briefly an owner of this house or something to that effect. And they're all on the same page. The only person who's trying to argue that, well, it wasn't a real transaction or there was something nefarious about it is Ms. Montgomery. So kind of with that in mind as a bird's eye view issue to address the individual counterclaims themselves, I kind of lump both of the quiet title counterclaims together. And they're based on essentially the same argument that this transfer between Miss Smith and Miss Berry caused some sort of cloud on Miss Montgomery's title. And we have a Georgia Supreme Court case, albeit from a little bit of an older case, but it's directly on point. Where in the case of Clark v. Woody back in 1944, the Georgia Supreme Court addressed the issue where someone came in and they said, hey, look, my co-owner of I believe it was like a 5/7 interest in a piece of property. My co-owner purported to convey his, quote, interest in the property to someone else, and now my title is clouded. Georgia Supreme Court comes back and says, no, it's not. He only purported to convey his interest, and he had an interest in the property. That is what he conveyed, and that is only what he conveyed. He didn't purport to convey your interest. You remain a 2/7 interest. Get out of here. It's not no basis for quiet title. And essentially the instrument in this case, I block quote some of it in the motion for summary judgment, but the instrument in this case is, and this is also Exhibit A of the Statement of Undisputed Material Facts. But
Exhibit A of what?
Of Miss Smith's Statement of Undisputed Material Facts in support of the motion for summary judgment. Mm-hmm. But the language is very clear in the quitclaim deed that Ms. Smith is only conveying all of her interests, rights, claims, title, and duties associated with the following property. So there's no attempt to convey Ms. Montgomery's interest in any way that would somehow cloud or make her less of an owner of the property. She's just complaining that she doesn't like the indirect effect of what that does to her. And so I would say just kind of on that argument, and then the remaining arguments kind of come together and coalesce around two cases. I think the quiet title issue fails for that reason. It fails also for a lot of the same reasons that the fraud claim and the slander of title claim fail, which is as you already kind of, I think you've hit on it by mentioning what the Supreme Court has said. This case boils down to Reed versus McConaughey and Vargo versus Adams. And they're two very recent Supreme Court cases.
The second case, I heard Reed versus McConaughey, which is MCCONATHY. What's the other case?
It's called Vargo versus Adams, Judge. And I can pull up the citation for you right now. It is 302 Georgia 637 2017. And in Reed versus McConaughey, it's almost a carbon copy of this case. You have a mother and daughter own a piece of property as joint tenants with right of survivorship. The mother wants to partition the property, so she conveys it to a third party who then conveys it back to her. And this gets argued up to the Supreme Court, and the Supreme Court says that's fine. That has effectively severed the joint tenancy with right of survivorship, and you guys are now tenants in common. You can proceed with the partition action. And Ms. Montgomery she doesn't really argue that that's what the Georgia Supreme Court's holding was. Instead, she argues that, hey, there's this footnote in it, and I believe it is footnote 3, but she says there's a footnote in this case that says that the daughter who was complaining about the transfer made an allegation of fraud, that there was something about fraud to the Georgia Supreme Court. The Supreme Court said, look, you never raised that below. We're not going to take it up now. So we're not going to say whether that would affect us one way or the other. Ms. Montgomery is here saying basically, okay, well, it's different because I am now arguing fraud.
Right. And
so carve this out for me. The problem with her fraud claim is that the basic elements of fraud are just not there. There's no misrepresentation of fact upon which Ms. Montgomery reasonably relied to her detriment. There's no statement to her. At most, at best, they've tried to raise a fact issue by saying that these quitclaim deeds allege that there was a $10 consideration for the transfer, and they're arguing that $10 may not have been exchanged. And we cited some law in the reply brief on that for decades now, the Georgia law's position has been, yeah, if the consideration for the transfer is not paid, then it doesn't invalidate the transfer. It just means that you can sue to get that money if you were the one that should have been the one to get it. And so it's still a valid transfer, but you may have a lawsuit for in this case, the $10 that may or may not have been paid. The second Georgia Supreme Court case sort of reaffirms what happened in Reed versus McConaughey and sort of looks at somebody and says, hey, look, didn't you read Reed versus McConaughey? We already addressed this. This is done. And it's a year later, and the Georgia Supreme Court sort of recast the facts of Reed versus McConaughey again. And that was a case where somebody basically brought a statutory partition action, joint tenancy with right of survivorship. He dismissed the statutory petition action because he rightfully saw the statute that you can't bring a statutory petition action for joint tenancy with right of survivorship. But then he tries to come back and go, I'm going to do an equitable partition now, and I'm going to get around this, fix this. And again, Georgia Supreme Court looks at it and says, nope, still doesn't work. Look at Reed versus McConaughey. And in Reed versus McConaughey, this same Georgia Supreme Court characterizes the transfer in Reed versus McConaughey as saying that was a transfer to this third party that was immediately transferred back. They use the word immediately in it. And essentially, they say, that's okay. That's Your Honor characterized it earlier as a straw man transaction. And essentially we have the Georgia Supreme Court's blessing that, yeah, that's fine. We can do that. We can do these back and forth real quick transactions. So there's that. There's nothing about these quitclaim deeds that they pointed to that are fraudulent. Like I said, parole contemporaneous evidence can't be brought in to vary them in any way. Their slander of title claim, she's also alleged that this has slandered her title in some way. Again, for the same reason that the quiet title claims fail. There's no one has slandered Miss Montgomery's title. No one's claiming she doesn't own it, that she's not a joint tenant, or that she's not a tenant in common with the property.
Is there any, I don't know if it's case law or theory that you've encountered, Mr. Sears, that Ms. Montgomery would have a claim of, hey, I used to have a joint tenancy, and a joint tenancy to me is something of value because if one of the two joint tenants, as you mentioned, passes away, we don't have to go through probate. good things happen automatically. And I place some value on that. And now my mom's gone and done what she did. I don't have that anymore. I am no longer a joint tenant. And so there's the slander on my title. I had a joint tenancy. I don't have it anymore. I'm a tenant in common. And life gets complicated if one of us passes away now as to what happens with this property. If it's my mother who passes away, what happens with that other half of the property isn't clean. I don't mean that's a cloud, but just that it doesn't flow automatically to me, Ms. Montgomery, with the passing of Ms. Smith. And I haven't seen any case law one way or the other, but would that be an argument to make that there's the harm to Ms. Montgomery's title? Yes, she still has 50% stake. There's no lien on it or anything like that. There's not that slander or cloud on it. But what she owns has changed. It's still 50%, but what happens with the other 50% is now different should Ms. Smith pass.
Yeah, I'm not aware of any case law that says that that would give her a basis for a claim. I have not researched that issue in any particular depth. We can if that's what Your Honor would like, but
no, I'm just curious if you've run into that.
I have not. But I also wouldn't necessarily characterize it as damage that she's incurred. I mean, the type of the sort of the nature of her tenancy has changed a little. In some ways, it is perhaps now. I'm not sure. It's more marketable now, just to some extent, because she could sell her. The people out there willing to buy a joint tenancy with right of survivorship, number one, can't, because as soon as she tries to sell it, it would convert to a joint tenancy or tenancy in common. I apologize. And you also have a certain issue of it's sort of these damages that she might suffer are highly speculative off into the future of, well, now what if my mom dies? What if there's a probate dispute? What if this? What if that? And it used to be cleaner, but now it's not. Finally, I'd say she can't really sue over something and say I was damaged by it if Miss Smith has the absolute right to do it. Someone else exercising their rights, even if it indirectly seems to make your life more difficult or more frustrating or costs you money in some way, doesn't give you a cause of action. They had the legal right to do it. And so I think here in this case, there have been no damages other than perhaps what you've suggested, that the nature of the tenancy has changed. But in terms of the damages, all Ms. Montgomery points to is she was concerned that there was something in a security deed that that was submitted for the mortgage that said, hey, look, if there is a transfer and we haven't approved it, we the bank have the option of possibly accelerating the mortgage and then demanding all of it at once. Again, this transfer happened in December 6, 2019. There's no evidence in the record that there's been any sort of demand of that kind. There's been any foreclosure. So these are all just sort of, hey, this could have happened, might have happened, it didn't happen, but here we are now. So there really hasn't been any damage. And there's also sort of maybe less relevant now that we're in motion for summary judgment phase, but there's also a pleading issue if she hasn't pled any special damages to substantiate her slander of title claim, which is a requirement as well. At the outset of this case, she had the obligation to come in and say, here is specifically how I was damaged by my title being injured. Didn't even make any effort to do that. Just said, used to have this, now I don't. Move forward, but she hasn't tried to monetize it. And special damages, as Your Honor knows, require a specific dollar amount for you to explain how you were damaged. The other kind of piece on the slander of title thing is even if there was some sort of on its face slanderous statement, which they haven't pointed to one yet, but even if there were, Ms. Smith is privileged to make these statements. There's an exception to slander of title in really all defamation cases, generally slander and libel. And it's if an individual is privileged to make the statement, then you can't sue them over it. And one of the privileges somebody can have, if they have a financial interest in the property or the relationship, or so I've seen some cases that suggest even in a person, that if making a statement about them when you have that financial interest, that becomes a privileged statement that cannot form the basis of a slander claim. And
what's
so
an example? I have not handled many slander of title claims. What's an example of a slanderous statement in the context of title? I handle lots of defamation cases. You're a dirty, rotten lawyer and you've never done good work, et cetera. Okay, I can parse through that. I was trying to think through, is it when one tenant a co-tenant says, this is a junkie house, and then someone might, that's not really title though. That's someone saying, you shouldn't pay 200,000 for this place because it's not so nice. I should know, I'm a co-tenant. What's an example of a slanderous statement in terms of title?
So I've encountered it in two scenarios. One is, and I can't recall the statute off the top of my head, but there is a statute that allows people to file affidavits in the property record where you essentially explain the circumstances of the ownership of this property. Usually that happens, and I say usually because the only instance that I'm aware of it happening was whenever someone died. And you basically file an affidavit in the property record saying, hey, the reason that there's this, it used to be titled like this, and now it's titled differently, is because there was this probate action, and it's usually accompanied with an order from a court or something like that. But you can file an affidavit in the records, and that affidavit can lay out certain circumstances of ownership. Like you can say, I tried to buy this. I was a party to a purchase and sale agreement, and this person tried to back out, but I tendered the money and I think I'm the owner. Basically, you're almost deliberately clouding the person's out because you don't want them to sell it until you can finish litigating the issue. And then the other time I've seen it come up are liens, invalid liens, where a contractor goes and slaps a lien on a piece of property and goes, oops, put it on the wrong piece of property. And then they say, hey, come take it off. And he goes, no, I refuse. And, those are the two instances where I know where we've had situations where somebody could say, okay, slander of title.
Okay.
With that, then the fraud issue, I think we've already kind of addressed this in the kind of larger context of Vargo v. Adams and Reed versus McConaughey. But basically, Ms. Montgomery's response brief tries to sort of invoke fraudulent conveyance law, and I know Your Honor has some experience with that because I've litigated a fraudulent conveyance case with you in the past. But fraudulent conveyance property now called, or fraudulent conveyance law now called voidable transactions, is just not applicable to this case. It's when someone is someone else's creditor and the person is trying to hide their assets from the creditor, and there's a whole bunch of statutory provisions that say when it's applicable and when it's not. And in the reply brief, we go through some of those and explain why we don't have those circumstances here. And so there's nothing about this transfer that was fraudulent. And again, they haven't even pled it really as fraudulent. They haven't explained with particularity what the fraudulent statement was, how they relied on it, how they were damaged. Same with the slander of title claim. It's just kind of boilerplate. Here's a counterclaim for you, and then they just kind of move on. And finally, with counterclaim 5, that's just the attorney's fees. Obviously, no attorney's fees under 13-611, because as we're arguing here, the other counterclaims all fail. They invoke the quiet title statute as a basis for counterclaims. I couldn't find anything, or I'm not aware of anything that would suggest that successfully bringing a quiet title action would automatically entitle you to your attorney's fees. In fact, that'd be kind of weird, because most of the time when you're bringing a quiet title action, there's often no opposing party in a quiet title action, because it's quiet title against the world and no one shows up to contest you. And then finally, they have a 9-15-14 argument, which until their response brief, they didn't have any facts to support it. But in their response brief, it seems to be based off of Ms. Berry's deposition, which Your Honor has already taken up in the past. It said you weren't going to award any sanctions for that. And also, we were the ones that helped ultimately make Ms. Berry's deposition happen. So on that, I'll turn it over to Ms. Gibson, and I think we're obviously reserving to come back and say anything in response to what she says. Thank you.
All right. Ms. Gibson, I've got a couple questions before you dive into your presentation. First, the actual property at issue, which is Lofty Lane. Is it a condominium, an apartment? It looks like there's a street address, but then there's a unit address. And so I'm just trying to envision where it is that your client, Ms. Montgomery, lives. I don't mean geographically, it's in Atlanta.
It's a townhouse community.
Townhouse. Okay. And then the second question is, as I understand the situation we're in, with a statutory partition, if that's where we end up, does Ms. Montgomery have the legal right to, in lieu of there being a partition, buy out Ms. Smith's share? Or is your understanding of statutory partition that means no, it needs to be sold to a third party, and in theory, I guess that third party could be your client, but it would be a sale of the entire property as opposed to just Ms. Smith's half of it?
There's no legal right for her to buy out Ms. Smith's portion, but oftentimes the parties will come to a resolution where an amount is proposed, because I think ultimately the partitioner just wants the cash.
Okay.
And so we've seen it where the sale may not take place and the parties settle, but under the law, the partition, there must be a sale.
Okay, so if a statutory partition is ordered, that might be the prompt or the leverage that would then allow the two parties to say, you know what, you don't have to sell this place, give me X dollars and you can have my half of it, and then you own it free and clear. And that would be fine, and there'd be no need for a statutory partition because the tenant seeking it is no longer an owner of any share of the property.
Yes, that's
okay.
That would be, that's how it normally works.
Got it. Okay. I am ready for what you want to share. Thank you for answering those.
Thank you. Is it possible for me to share my screen?
Yes, ma'am. You should be able to do it. If I need to somehow push permission to you, I'll do that. Nope, you're doing it. Great.
Okay. I just want, if you would indulge me 2 minutes, I think that this would help me to explain my argument.
Sure.
And now the end is near, so I face the final curtain. My friend, I'll say it clear, I'll state my case, of which I'm certain. I've lived a life that's full. I traveled each and every highway, and more, much more than this, I did it my way.
Okay, so I played those two songs because I think it will help me to demonstrate the case that we have in front of us. In order to partition a property, you cannot be a joint tenant with right of survivorship. So you have to sever the joint tenancy in order to partition. The judge made clear that that part he's clear on. So in order to do that in Georgia, under the statute that we have, 446190, you have to give it away. So that's why I played the Red Hot Chili Peppers. You have to give it away. Now, Compare that to New York Real Property Law Section 240B, and I included that in your materials. You can do it like Frank Sinatra, your way. You can give it to a third party. You can even convey the deed to yourself and say in that deed, I intend to sever the joint tenancy and I am now a tenant in common. That is totally different from in Georgia. You have to give it away, like the Red Hot Chili Peppers. And the issue here is, did Ms. Smith give it away to Sydney Berry? And the answer to that is no, she did not. Because in Reed versus McConaughey, the court was clear that they did not develop the record in the underlying case factually for them to come to a decision that Reed did not convey that property to Page. If you read the language in that case, it says when Reed conveyed the property to Page, Page could have done whatever she wanted to do with the property. So the statute looks at what Reed did, which was give the property to Page, and the case, Reed versus McConaughey, looks at what Page had after that. She had a choice. So in this particular case with Ms. Smith and Ms. Berry, they had testified in their deposition there was no choice. They predetermined the outcome before the conveyance. So Smith and Berry contacted the firm, said they wanted to do this transfer back. And Berry testified that when she received the deed to the property, she didn't have a choice of giving it to a third party or keeping it for herself. There was no choice. She was going to give it back to her mother. You know, if you read the facts, and this is why summary judgment motions are viewed in the light most favorable to the non-movement, and whether or not there's a factual dispute here as to whether or not there was a conveyance. And we feel that there are significant facts to show that a trial should be held on whether or not there was a transfer, whether that transfer was correct. So one of the issues is, Berry says, when I received the property, I had no choice to keep it. I was going to convey it back. They sat at the same table, they did the deeds, it was notarized at, I think, a FedEx, put in the envelope and mailed back at the same time. They said it didn't take but 20 minutes or less. There was no consideration for the transfer, no money paid. Typically, when you transfer property, you're supposed to notify the homeowners association, none of that done. There was no notifying the taxing authority. Berry never paid a mortgage payment, never anticipated paying one at all. There was no transfer. This deed was just a farce. It was not worth the paper it was written on, because they initially agreed beforehand that Berry would convey it back to Montgomery. So
I'll make sure I'm following you. I think I am. Mr. Sears views Reed as standing for the proposition that basically doing a straw person transfer can sort of make Georgia like New York. It's the way to do it your way, because you can just sign some paper saying I'm transferring it to someone who really isn't ever holding it other than to bounce it right back to you. And Mr. Sears says, Reed says that's okay. Your point is, first of all, that's not what happened in Reed. The transferee was free to do with it as she or he wanted, but happened to return it to the transferor. But here, our case, Ms. Berry has made clear, if I had had a change of heart when my mom transferred this to me and I said, you know what, Mom, I want to move in with my sister. I want half the place. It's all mine. She couldn't have done that based on whatever arrangement she had with her mother. I think the phrase you used was she had no choice but to send it back. And in your mind, that distinguishes this case from Reed. And you're arguing that there isn't a sort of Sinatra way to destroy or get rid of the joint tenancy. It needs to be a bona fide transfer I guess I would call it an arm's length transfer, so that maybe the transferor gets it back, but maybe not if the transferee decides, I actually like having a co-tenancy with the other person.
That's correct, Your Honor. I don't know if you've ever been into those government offices where they have the pens and they have the big flower on it, and they say you can use the pen, but you need to put the pen back in the box. So Ms. Smith, she never let go of her control, her authority over the property. She only let Cindy hold it for 20 minutes, but she got it back. That was simply just to destroy the severance. And then that makes you a New York statute, not a Georgia statute. And that there's a difference. If the legislature wants to change the statute and do it like Sinatra and say, hey, you don't need to give it to a third party, then they should do that. But if there's a statute that says it has to be given away for your lifetime, then they should actually give it away for the lifetime and not play games with the pass and pass back. The only reason why in McConaughey, the court had no facts underlying to come to that conclusion. So yes, on its face, they're going to take the word of the deed. But I cited case law in my brief that says the court does not have to look to documents that are simply on their face in order to decide cases, that you can look behind the deed to determine whether or not a deed is actually a valid deed. In Barkley versus National Security Fire and Casualty Company, the insured made a claim on a piece of property that had a fire, and the insurance company denied the claim by stating that, hey, you've transferred your property. You don't own the property anymore. And the insured received affidavits from the grantees stating that there was no delivery of the deed, there was no consideration paid, and so the deeds that were recorded were not valid. And the court stated that the Court of Appeals reversed the trial court and said the trial court does not have to simply accept the writing on the face of a deed conveyance. When consideration and delivery were challenged by the grantor and grantees, there is a question of fact presented. The court also encouraged that the court would look into the quality of ownership by the owner, i.e., what evidence did the owner present to show that he literally owned the property? So in this case, that brings us to another issue of what is the quality of Ms. Smith's ownership? My client, Ms. Montgomery, says, when we sat down at the closing, my mom gifted me a down payment. She wanted me to be a homeowner. And this was a just in case. Something happens to me, you get the property. Something happens to you, I get the property. But my mom was encouraging me to be a homeowner. Since that time, 2006, I pay the mortgage. I maintain the property. Something breaks, I fix it. I lived here and I pay the HOA dues. My mom does not even come here and stay long if she does come and visit. When they did get along, it was a weekend trip or something to that effect. In fact, Sydney Berry lived there and had to pay Montgomery mortgage. So, rent. So Montgomery has exercised occupancy and all the benefits and burdens of ownership over this property since 2006, whereas Smith only gifted that money. And in fact, Smith filed bankruptcy in 2011. And I also included that into your documents. In 2011, Smith filed bankruptcy. And I will share my screen again. She claims in her bankruptcy, which she swore an oath, that the only property she owned was her property, the duplex in Oakland, California. It says, list all real property in which the debtor has any legal, equitable, or future interest, including all property owned as a co-tenant community property, or in which the debtor has a life estate. This is the only property that she listed. She did not list the property that Miss Montgomery owns. She was able to discharge, as a result of this bankruptcy, close to $1 million in debt. She told the bankruptcy court and all of her creditors that the only thing she had was a primary residence, and that was exempted. So in essence, she received a significant benefit by hiding her ownership when it suited her, because in fact, she knew she doesn't own this property. She just bought it as a gift. She gave a gift down payment to her daughter, but that property was not an ownership in her mind at that time that she owned that property. Either she lied then, or she believed she didn't own it and then changed her mind later on. The other thing that I wanted to bring up was she did not have the automatic right to transfer the property. When you sign a deed and you sign a mortgage, which Ms. Smith and Ms. Montgomery did together, Ms. Smith does not have the automatic right to transfer property and transfer it back. What she's doing is creating a default issue for the mortgage company for Ms. Montgomery, because in every mortgage, there's usually a due on sale clause. It triggers a default. And by her transferring to Sydney and transferring back, she is endangering Ms. Montgomery and causing her to be open to a default, which could mean a foreclosure. So back to the issues that we filed, a counterclaim. Quiet title. We state the quitclaim deeds are invalid and they are a cloud on Ms. Montgomery's title. The reason why they are invalid, we went over. They don't have any external indicia of what happens when you convey property. No consideration, no taxes paid, no reporting to the HOA, etc. But also, they never had an intention to transfer the property. In the deposition testimony that I asked Ms. Smith, and I said, Ms. Smith, on page 65 of her deposition, I asked her, question, when you sign a deed over to Sydney, you intended then that Sydney would sign the property back over to you, correct? So at no point in time was Sydney ever supposed to be the legal owner of this property? No, ma'am. She says it. She never intended that this property would be transferred. Sydney also said the same thing on page 42 of her deposition. She said, repeat the question again. I said, I'm trying to understand what was your agreement with your mother. As I mentioned, this is something that she wanted me to do. She was getting her things in order. And then I asked her, I said, I was very specific with her. I said, so the question is not whether you want to, but whether you had the choice to keep the property. And she said, I said at the end of my statement, I said no. At the end of my statement, I said no. Question, no. So you didn't have a choice to keep the property? No. They never intent, this was not a true transfer. There was no.
Can I stop you for a second? Can you go back to that screen? I just have a question about something you just shared. What is the statement that Ms. Berry is referring to? You were reading lines 14 and 15. Ms. Berry says, at the end of my statement, I said no. She repeats that. What statement is she talking about? Just something else she said in the deposition? Or is there some statement she gave to law enforcement or to an affidavit? What is the statement?
She was, when I asked her, did you have the choice to keep the property? She went into saying, my mom pretty much asked me to, if she could, deed the house over to me and I would deed it back over to her so that she can, do what she needed to do in order to get her affairs in order. I don't know the specific proceedings that her and her lawyer had discussed in regards to that, and I said, okay. And she said, I
can read it. You don't need to read it into the record. So that's the statement you think she's referring to when she says, at the end of my statement, I said no?
Yes, she's referring to her prior answer to my question.
Okay.
Mhm.
Second question. What is the cloud on Ms. Montgomery's title? That's the part I've had trouble working through. I'm following you real clearly on, hey, was this a legit transfer or not? And is it a inappropriate way to basically turn Georgia's statute into a New York statute? But setting that aside, I know you are arguing in effect that Ms. Montgomery is 100% owner because Ms. Smith didn't include it on her bankruptcy petition and some other parole evidence of, hey, this is a gift, I'm here just in case. But you, Ms. Montgomery, are paying everything for this place. Nonetheless, the property records show that it's 50-50. Originally, it's joint tenants. Now it's co-tenants. But what is the cloud created by the quitclaim deeds on what Ms. Montgomery has based on Fulton County property records? It seemed like she had 50% before and she's got 50% now. And there's not a lien on her 50% that wasn't there before. There's not a extra mortgage that Ms. Smith took out, burdening or encumbering the entire property. As free and clear as Ms. Montgomery's stake was, sounds like subject to first mortgage, it is just as free and clear now as it was in 2010. It seems like to me. So tell me what I'm missing.
Well, I would say, Your Honor, the cloud on her property is that she's no longer a joint tenant with right of survivorship. Now she is a joint tenant in common. And that's a totally different way to own the property. When you are a joint tenant with survivorship, you can't sell the property. The property is 100% to each person if something happens to the other person. And now what she's doing is she's changing that entire ownership to a tenant in common and forcing a sale of the property. That was not the understanding when they initially went into this transaction. And if Jolene Smith wanted to do that, if she wanted to transfer it, interestingly, who would she transfer it to? The third party would not buy it for 50% because it's not worth 50% to become a tenant in common in this particular situation. So that's why she did that inside deal with her daughter. Because number one, if you bought a piece of property from a joint tenant, a survivorship, if you let's say I want to buy this from you, you would have to, number one, value it according to what the equity is in the property, the mortgage already. And Ms. Montgomery has a right to challenge what Ms. Smith's actual ownership value percentage is. And in Ms. Montgomery's case, she's saying it is not a 50%, 50-50 ownership. It is more like a 95% ownership, if anything, because my mother gifted it to me. But after she gifted it to me, she never really took care of the property at all. So no one would buy this property from Ms. Smith straight from being a joint tenant with rights of survivorship. It's almost like it has no value. And so
have you found, now I follow you. I am curious if you found any case law that says converting a joint tenancy to a tenancy in common means you've put a cloud on the now tenant in common's title. I appreciate that it makes it something different. Agree 100%. It does make it something different. I'm not a property law expert. That is definitely your field. That's where I bump into you in these property cases. But I'd be surprised, I like being surprised, if there is a case out there that says that's a cloud, as opposed to it's a change. The nature of your ownership is different, but you still have 50% encumbered in the very same way it was encumbered before, mortgage, et cetera. but that's not a cloud.
Right, I don't have a particular case that says changing a tenant in common from a survivorship to a tenant in common is a cloud on the property. What we're asking the court to do is determine what ownership, if any, equitably does Ms. Smith have in the property, given the facts of this case.
Okay, got it.
Talking about the slander of title claim, I talked about this briefly, which was that the mortgage says, and that's paragraph 18. I filed it as exhibit 3 to the motion response. Paragraph 18 includes a due on sale clause, and I cited a case in my brief stating that a due on sale clause in Georgia is valid. And so Montgomery is currently in default of the terms of her security deed and is subject to acceleration just by the fact that Ms. Smith transferred the property out of her name and then transferred it back. And that is, you're not supposed to do that when you have a first mortgage. So lastly, we talked about the fraud claim, and deeds are to be analyzed under contractual principles of fraud. So Top Quality Homes, Inc. versus Lenora Silver Jackson, that's 231 Georgia 844. In this case, the fraud happened because there was no true intent to transfer the property. And I did talk about the fraudulent transfer of property, the fraudulent conveyance claim, because it's very similar to that in this sort of situation where a family member would transfer to another family member in order to avoid indebtedness or insolvency. But it also it also looks like Thomas Moat Trucking versus PCL Civil Contractors, Inc. That was an interesting case where someone was trying to avoid bankruptcy and drafted a note in order to look like they were selling one of their construction trucks to another party. They never transferred any money. There was never any transfer of the actual truck, but they were doing it just in case, hey, if I file bankruptcy, I don't want the trustee to take this truck. Later on down the line, about a year later, they actually tried to sell the truck to another party. And the first party who had the first note said, no, they sold it to me. And the court says, the court could have concluded that that May 15th letter was not a sale or transfer at all because the parties never intended it to be so. Parole evidence is admissible to show that the contract was void from the outset. The court went on to state several additional facts support this interpretation. And the fact that there was no money paid, that they weren't acting as if it was a transfer, showed that that first note was really just a fraudulent piece of paper. And that's what happened in this case, very similar. That transfer and transfer back was not at all valid. It was void ab initio from the start. They planned it that way. They executed it that way for the sole purpose of severing a joint tenancy with right of survivorship.
So I follow your argument on that, and that may be a basis to unwind the transfer, but in your counterclaim, you pled fraud, and fraud has as an element detrimental reliance and also damages. And I'm having trouble figuring out any reliance Ms. Montgomery had. She's understandably frustrated by what happened, but I don't see how she's a victim of fraud. I need to say it carefully because you've explained why she feels like she's the victim of something that happened that wasn't according to the way things ought to happen. I don't know that it's fraud because, in fact, here is your client actively trying not to rely on what happened. She wasn't fooled by anything. The classic fraud is someone says, hey, give me $100 for this fantastic new iPad. And it's not a new iPad, it's an old broken one, but someone relied on it, paid $100, and they got a lemon. I don't see Ms. Montgomery relying on anything other than you as a good lawyer trying to undo this situation. And so that's the part where I'm struggling with the fraud allegation, because it doesn't sound like Ms. Montgomery was ever tricked, or deceived, or misled by it. She wasn't asked to sign it, the quitclaim deed. She hasn't been asked to do any of this. It sounds like, regrettably, for a family unit, this has been real divisive for your client and her mom. And I get that. I can't fix it. But it just doesn't seem like it's fraud on your clients. Maybe there's fraud in the real estate records because people are claiming there was this valid exchange and the $10 wasn't paid, et cetera. Although I think there's case law that will help me navigate that. But let me just step back to you alleging fraud, which would require your client to have detrimentally relied on some misrepresentation by Ms. Smith. And to me, the fraud claim, as in I'm a victim of fraud, falls apart once you get to the justifiable reliance, because your client is steadfastly refusing to rely on the quitclaim deed. That's not a good quitclaim deed. I don't accept it. It's a joint tenancy, and basically I'm the one who's paid for everything on this piece of property. So you could take it down the equitable road later. But I just want to work through your argument and count 4, which alleges fraud.
So my client says when she sat down to buy this property, she was explained that, and she said this in her deposition, she was explained that she was putting her mother on just in case. It was just in case something happens to you, the property would go to her mother. And that was why she agreed to have her mother placed on the deed in the first place. Now it's turned to sell the property, the market's hot. And that was not the understanding that they went into purchasing this property and putting her mother on the deed. And so the material misrepresentation started initially, put me on in case something happens to you, honey. And she relied on those statements. She did the joint tenant with right of survivorship. And now the market is hot, I need money. That's the fraud that she has been injured by at this point.
Got it. Okay.
So we would ask the court to deny their motion for summary judgment and essentially have a trial on the merits of the case. The parties can put forth their evidence as to what is the quality of ownership of this property and what is the true value of the individual's ownership.
Got it. Thank you. That was very helpful. All right, Mr. Sears, I've got a couple questions for you, and
Yes.
then you may have your own line of rebuttal that you want to pursue. And let's start with what was shared most recently. So Ms. Gibson's helped me understand more about the fraud, that the promise that was relied upon to the detriment of Ms. Montgomery was this representation way back when the property was acquired in June of 2006, where mom allegedly says, hey, you know what, I'm gonna get on this deed. It's your first house. Let's try to keep this simple and safe. And so I'll be your joint tenant, but this is your home, as evidenced by the fact that Ms. Montgomery is the one who has paid the mortgage and lived not quite exclusively, but essentially exclusively in that unit since it was acquired. Well, I guess initially it was rented out. And maybe that's your answer. It's like, hey, if this was going to be just for Ms. Montgomery, why was it rented out for 6 years till 2012? But either way, I want to give you a chance to respond. I may have answered my own question as I look at the timeline, but your turn.
Correct, Your Honor, and that's one big point. I mean, they had renters in this piece of property for 6 years, paying. They were receiving rental income on it, and that was they were paying the mortgage. They were paying the fees associated with the property. Miss Montgomery keeps saying she's paid everything associated with this property. She's paid it. She's paid it. She's paid it. That's just not true. At the very least, for the first 6 years that they have the property, it's like any other rental piece of property. You're getting rental income, and then they're splitting it up, and then they're paying off the costs. So it's not particularly. She wasn't doing anything unique to her that Miss Smith wasn't also doing in that situation. So you could say Miss Smith had the legal right to 1/2 of that rental income that was coming in, and she was chipping in and paying part of that mortgage, part of the utilities, part of the taxes, all that.
Is it in the record where Ms. Montgomery lived those first 6 years that she and her mother jointly owned Lofty Lane? I don't mean the street address, but was she living with her mom somewhere else, or she was doing her own thing and she and her mother co-owned a piece of investment property?
I don't believe that is in the record. Is a. Okay. I'm sorry.
It is in the record.
Okay.
Okay. What's the answer?
She initially lived in Lofty Lane, then she moved to her mother's, to her house. Her mother had a home in California. She lived there, rented from her mom while she was in school. And when she finished school, she moved back to Atlanta.
Okay.
So I don't recall that particular set of facts, but I'll take Ms. Gibson at her word and say that's fine as far as we're concerned.
Okay, it's not critical. I was just curious.
Yeah. So so number one, with regard to that issue, Your Honor, I think your question was the fraud is actually based off of some sort of, I guess, subjective. She didn't really intend to. I guess I don't quite follow Ms. Montgomery's argument on that. That the idea that it would seem that Ms. Montgomery got exactly what the agreement was, which is that they were going to be joint tenants with right of survivorship. I'm not sure if she's trying to argue that there was some sort of affirmative misrepresentation that this property would never be sold and that this would just be owned in perpetuity until one of us dies.
What I heard Ms. Gibson saying, and I appreciate that this isn't recorded anywhere in any purchase agreement or any deed or whatnot, is that Ms. Smith put her name on the property to help her daughter, Ms. Montgomery, with this first purchase. And it was more as a security, not in the sense of real estate transactions, but maybe it helps get the loan, maybe it helps with the transaction to have someone more established also on the property, but that what, according to Ms. Montgomery, through her lawyer, what Ms. Smith represented was, this is yours. My name is on here just as sort of a safety blanket. This is your property, which is why Ms. Montgomery was expected to pay for everything.
Okay.
And now all of a sudden, your client, Mr. Sears, swoops in saying, I can make some good money off this because it's now worth, I'm making it up, 3 times as much as we paid for it. So let's sell this baby and I'll take half of the net gain.
Right. Well, so number one, Judge, I mean, I think to kind of what you've already alluded to with regard to just what's in the documents, and that's, I think, what we're stuck with, rather than going into the parole evidence of what may have been said in 2006. I think they have a massive statute of limitations issue, because statute of limitations is going to be 4 years on any sort of fraud claim. But I think probably the most obvious issue with this new argument they have of what constitutes the fraud in the case, that it's not what they pled in their answer and counterclaims. They have count 4, which is fraud. They have 1, 2, 3, 5 paragraphs about it. And it says, petitioner knowingly and intentionally forged signatures on a fraudulent deed and failed to pay consideration in conveying the property to Sydney Berry and then back to herself. Next paragraph says, petitioner knew at the time that she was forging these signatures and making these fraudulent conveyances that it was a fraudulent act. And then next, the whole world who looks at the fraudulent deeds reasonably relies upon the signature set forth in the fraudulent deed and the declaration of consideration. And then she talks about her damages. There's nothing in here about you lied to me in 2006 and said this would be mine forever and you would never try to sell it. This is a new argument I think is at some point they've realized that they don't really have a fraud claim for the quitclaim deeds, and they're kind of trying to pivot to saying, well, back in 2006, you made a misrepresentation to me. I don't think that gets them anywhere. I think based on the language in the original joint tenancy with right of survivorship deed, it fails. I think based on the statute of limitations, it fails. I think I don't think their argument really works that well from a common sense perspective, because there's not a real strong reason that Miss Montgomery would need her mother on the deed that I can think of, other than maybe the one that you suggested, that there was something with the bank wanted to have somebody more established on it. But either way, it doesn't get them there. It doesn't rescue their fraud claim. And so that's kind of on that fraud issue. I think we've addressed that. I did want to correct one thing that Ms. Montgomery said about, I think first thing you asked her was, is there some sort of mechanism for a buyout under the statutory Partition Act? And maybe we're interpreting the statute differently, but I would say that my understanding is under OCGA 44-6-166.1D. And I'm actually not as tech savvy as Ms. Montgomery in terms of screen sharing, but actually, yeah, never mind. What am I saying? Here we go. Let me try this. Let me see if I can. This is the stat. Everyone can see my screen here. So here in section D, it says basically there's going to be this appraisal, and it sort of sets forth the mechanism of what's going to happen. It says within 15 days if the appraised price is established. I won't read the whole thing to you, but it basically says that the petitioner can get bought out by one of the other parties in the case based on the established appraised price. And the way I've envisioned this case going is without the counterclaims in the case, we obviously don't really have a jury issue anymore. This is just a straightforward, equitable, or a partition action that Your Honor can probably hear in a bench trial. And there will be this appraisal process will happen. The court will get the appraisal, sort of establish the value of the property in court, and then look at Ms. Smith and Ms. Montgomery and say, do one of you want to buy the other one out? And there is some language in here at D about the petitioner can say, I don't want to be the petitioner anymore because I don't like the appraisal price. I don't want to be the petitioner anymore. And the other person can say, well, actually, I do like the appraisal price, so I would like to be the petitioner. Any number of different things can happen. And so they can switch places, or something like that can happen, and they can buy each other out. The sale only comes in when no one wants to buy the other person out. And then you can go and you do this sale process. That's my understanding of it. I'm open to if Ms. Montgomery.
No, I don't know that you two are saying different things. When I was engaging Ms. Gibson on this, I was just trying to understand in her experience how these things played out. And what I heard her say is, you know what, oftentimes, Judge, you don't get to the partition because the two sides, maybe after the appraisal, maybe before the appraisal, say, we see what's coming. It's a whole lot easier. I'm gonna strip you a check for $100 grand. I don't know how they get $100 grand, but they figure out a way to resolve it. And informally, party A buys out party B, which certainly is okay. They could do that tomorrow before I rule on the motion. What you're highlighting is statutorily, there's a mechanism for it as well. So I don't think you guys are in conflict on this issue. I was just trying to understand if Ms. Montgomery was laboring under the misapprehension that the only outcome was that a third party was going to acquire, if things didn't go well for Ms. Montgomery, the only outcome was that a third party would acquire the Lofty Lane townhome. And Ms. Gibson said, not at all. Usually what happens is that, all right, I see what's coming. Let's not put it up for sale because someone could swoop in, and I just soon stay in my place. It's been my place for years. So what's it going to take, Mom? And you guys sort all that out. With the leverage being, a judge has said there's going to be a statutory partition. So, and that can happen informally, or as you pointed out in subsection D, it could happen. I don't know that it's more formal, but someone could say, I want to rely on D. So I hear you. I just don't know that that's all that different from what Ms. Gibson was saying. I just wanted to make sure I understood if in fact the law was, if a judge says this needs to be partitioned it would be an odd law, but I've bumped into odd laws before. Neither co-tenant is permitted to be the purchaser, because then maybe it's not an arm's length transaction. And the whole point of the partition is to get some independent third party to come in to say, I will buy this based on its actual fair market value, and that's $800,000. And then the poor occupant, one of the two co-tenants in this case, is left with $400,000, but not a place to live anymore. And that is a possible outcome, but it is not the statutorily required outcome. That puts me at peace on that issue. All right, back to you.
And so with that kind of out of the way, then I was going to also just address the argument that they made that there's no choice. Miss Berry had no choice to keep the property. Again, this again goes back to the Reed versus McConaughey. They look at the language of the instrument. That there may have been this sort of verbal agreement between them that, hey, we're going to transfer it right back. It's just irrelevant. It doesn't even come into consideration in terms of legally what the effect of the transfer is. And there's also the issue of, this is a transfer of real property, which falls within the statute of frauds. And so even if there was some sort of verbal agreement that, hey, Ms. Berry, now you need to transfer it back to me, Ms. Berry, even though she may have felt like she didn't have a choice in terms of she's not going to, go against her mother and ruin that relationship, there might have been an emotional, personal aspect to all of this. Legally, she could have walked away with the property under the plain language of the quitclaim deed and under the statute of frauds, and she wasn't bound by what this verbal agreement may have been. And there's nothing in the record to suggest that they had any sort of written signed agreement that would have been enforceable against both sides. So to the extent that I think when she was quoting the language in the deposition about the no choice language, Miss Berry, she's not an attorney. I believe she said she was an actress. And I think she's speaking more colloquially and not in terms of what her absolute legal rights are. So just kind of wanted to flag that. One of the other issues that Ms. Montgomery brought up is with regard to the Barkley case that she mentioned. This was an insurance case. It's a Georgia appellate court case, 170 Georgia App 17. Essentially, Ms. Montgomery relies on this case for the proposition that, hey, a court can sort of look beyond whatever is in a deed and invalidate it if they want to. And that's not quite the holding of Barkley. Barkley basically, as Ms. Gibson correctly said, in Barkley, they basically said, look, this deed was never delivered to the other side. And it essentially, there was strong evidence to suggest that it was never, no one ever paid or received any consideration for it. And one of the actual parties to the transfer was sitting there saying this never happened. And they said in those circumstances, then yeah, you can look into it and say, look, if the guy that supposedly transferred is saying the transfer didn't happen, the other side's saying we've never had a deed delivered to us, we never paid any consideration, he never received any. Then the court said, well, yeah, there could be an issue here where, yeah, maybe the transfer didn't really happen. We don't have that here. Both Ms. Berry and Ms. Smith are adamant that, yes, we signed this. Yes, this happened. So I don't think Barkley changes anything. Kind of the other issue that Ms. Gibson made several points about was the quality of ownership and sort of how she envisions this maybe shaking down, which is maybe more of an argument for when we're deep into the partition action aspect of this. If the property gets sold and neither person wants to buy the other one out, this court sells the property and now there's a big pot of money sitting in the registry of the court, and your honor has to decide, okay, well, do we split it 50-50? Does one person get more? Does one person get less? The quality of the ownership issue, I would say, is more appropriate to be taken up at that point, to the extent Ms. Montgomery wants to come in and argue that, hey, because I did more for the property, I should get a greater share of the proceeds. But just to address a few things on that, we already talked about the renters and the fact there was this rental income for a while. Ms. Montgomery, though, on the one hand, she's arguing, well, I took care of the costs of this property for at least the last 9 years. And when we had renters, half of that money arguably was hers that was going toward the mortgage and the taxes. So she says, I've taken on the bulk of the cost for this property. But for the last 9 years, or 10 years, I guess, or going on 10 years, she's received 100% of the benefit of the property. And so I don't think it's unusual to say that you would be responsible for taking care of these costs that, you know, otherwise would have been covered by rental income because you're the one living there. Ms. Smith hasn't shown up and said, you know, actually, since I'm a 50-50 owner with you, I'm going to live here too. And, you know, I'm going to impose all these rules, or I'm going to try to kick you out and put a tenant in. Ms. Smith.
Is there anything in the record showing that Ms. Montgomery has been required to pay rent to Ms. Smith for that 50% stake that Ms. Smith has, for which she is arguably getting nothing right now?
She has not paid any rent to Ms. Smith. Essentially it's cover all the costs and stuff, and then you just get to live there. And which obviously, you know, it's a good deal for Ms. Montgomery, and I understand why she wants it to continue. But that's just legally, she can't just hold on to this indefinitely like she's trying to do. So there's kind of that quality of ownership piece. Ms. Gibson brought up the bankruptcy action aspect of things. You know, to the extent there's been something left off of a bankruptcy petition, the legal effect of that is not that, oh, okay, now you no longer own this thing. It is arguably, if Ms. Smith's creditors wanted to go back and reopen her bankruptcy to try to levy on some interest in that piece of property, they could. Or, you know, the bankruptcy court could evaluate that at the very least. The effect is not that she just doesn't own it because she didn't include it on her bankruptcy schedule. So there is that piece. And then she said that Ms. Smith's transfer of the property has caused a default under the mortgage. Just to nitpick a little bit, it hasn't caused a default. It's just basically given the lender the option to do a due on sale provision that is totally optional. It's not saying you guys are in default and all this cascade of horribles is going to come. It's just that we can accelerate. And like I said, this happened in 2019. No one has tried to accelerate. No one's tried to foreclose. No one's done anything.
But let me press you on that a little bit, because I heard Ms. Gibson say two different things. One is what you said, but when she and I engaged on it a little bit more, and she was referring to paragraph 18 of the mortgage, the due on sale provision. She changed that a little bit to say, now Ms. Montgomery is subject, it really would be both parties in this case, but Ms. Montgomery is the one living there. She's subject to acceleration because of what her mother did. And I'm viewing this not as cloud on the title, but slander of title. There was title that Ms. Montgomery enjoyed that was burdened by the mortgage, but it was a mortgage which, if she maintained regular payments, which it sounds like she has, is a mortgage. And she's able to juggle that through her professional obligations, et cetera. Now, the deal's a little different. She could open the mailbox tomorrow and there could be an acceleration notice from the mortgage company. And that would be, it sounds like, valid under the terms of the mortgage and caused not at all by Ms. Montgomery, but 100% by Ms. Smith. So that's not something that Ms. Smith said. Like you mentioned, there are these affidavits that people might put together when there's probate, et cetera. We're not there. But as I think about slander of title, there's this action that Ms. Smith took that has, as an unintended or intended, nonetheless, consequence that Ms. Montgomery's enjoyment of her title is a little more tenuous, or it's more complicated. So how is that not a adverse impact that ought to be viewed or interpreted through the lens of slander of title? Well, so as we talked about previously, nothing has happened yet. And in the meantime, for the last year and a half, the lenders, we can check the property records, but the lenders have continued to receive their regular monthly payment. They accept it. And I believe that the note has even been sold to a third party since then, and who presumably would have run title and said, oh, I've got a great opportunity to accelerate this thing. Nobody's done it.
And so as a result, there really are no damages yet. They probably, it's really a speculative damage claim of what might happen in the future. So I would say, number one, there's that. Number two, although it is nominally related to title, there's nothing affecting her actual title to the property itself. This is just, hey, there's this separate note over here that may be implicated because of this transaction. And, it doesn't actually, no one's saying that she doesn't own what she owns in the property. It's just saying that there are some other obligations that may be affected. And then I'd say number three, the privilege argument still applies. Ms. Smith signed the security deed too. She's a party to this. And so she has the financial interest in the security deed and in these provisions. And as a result, any statements, to the extent we're going to rely on a statement made in one of these quitclaim deeds, it's still privileged. And so I don't think that gets them anywhere for the slander of title claim. And then the Thomas Moat issue, I think we addressed both the Barkley case and the Thomas Moat case in the reply brief. And so I won't belabor them too much, but the Thomas Moat case just dealt with a transfer of a truck. It wasn't a real property case where we had property records or anything like that. And there was a disputed issue of who bought what when. And essentially the court went and said, if there is one party said, I bought it later, this party said, I bought it earlier. And the main question was, well, when did the party that originally owned it, when did they own it? When did they stop owning it? And I think that is night and day different than what we have here, where we have real property that is subject to a whole different set of laws that have all of these instruments and transfers and stuff are well recorded, easily verifiable in the property records. And the actual parties to the transaction aren't disputing it. There is no third party here saying, actually, no, I bought this property. So I just don't think that's applicable at all. And on that, Judge, I would say that would be my rebuttal. Unless you have any more questions, that would be my case.
No, I asked my questions, or I was going to ask you one other thing, but you answered it through what you went through. Ms. Gibson, I'm not going to have a back and forth, sir, rebuttal, et cetera, but anything in particular that you just heard from Mr. Sears, like, oh my gosh, I will not sleep well tonight if I don't get a chance to play a third music video that is perfectly responsive to what he just said.
Music. I did have another. No, I'm not going to play the third song I was going to play, but I will say that the ownership, I wanted to clear that up.
Mm-hmm.
In the occupancy. So Miss Montgomery lived in the property after it was closed. Then she went to school and moved to California and lived in one of her mother's rental properties and paid rent to her mother. She managed, and that's all in the deposition, she managed the tenants that were there. She's the one who collected the rent, paid the mortgage. Then she moved back from California after she finished school back to the house.
Okay.
And there's some time when Sydney lived there and went to school in Atlanta with friends and paid rent to Miss Montgomery. But for the most part, Miss Montgomery has been the one that handled the benefits and burden of the property for the entire time.
Is it in the record who received the rent money from Lofty Lane when your client was out in California in school?
Yes. So Miss Montgomery collected the rent, paid for the expenses, managed all repairs.
Okay, you just said that. I thought you were referring to when she was living in her mom's place in California, she managed that place. You're saying, I got it. So when your client was in school in California, she was remotely managing Lofty Lane. If I was living in it, I'm paying the rent to her. When I call her to say, dang, the sink is leaking in the bathroom, your client's the one who's arranging to get it fixed, et cetera. I don't call Ms. Smith. I don't send money to me. I don't send, if my rent's $1,000, I don't send 500 to Ms. Montgomery and 500 to Ms. Smith.
Correct. That's how it went. And then when she was paying her mother rent while she was in California. So,
but not rent on Lofty Lane, rent on Jones Street in California. Yeah. Okay.
Yes.
All right. Got it. Well, thank you so much, Mr. Sears, Ms. Gibson. This has been real helpful. I'm sorry that the Smith Montgomery Berry family is divided over this piece of property. But these things happen. They remind me why I'm glad I'm not in the family division. And so I don't come across family struggles like this all that often. But I appreciate that it's important to everyone involved. It's someone's home. And so I will be thoughtful about this and looking at all the pleadings. One of two things will happen after I confer with Ms. Niles, who's been sitting in here listening as well, just to get her perspective on it. Either I will write an order, say, here's what's happening, or I may have Ms. Niles, she'll reach out to both sides, but I may have her reach out to say, you know what, the judge has looked at the case law that people were relying on, et cetera, and would like party X to take up the pen and put together a draft order. That draft order would be submitted to everyone, and the side that wouldn't be prevailing as a result of my preliminary ruling would be free to offer proposed edits to the draft order, not to change the outcome, because I would have already said, look, this is how I see this thing shaking out. But there could be factual errors, or hey, I think you need to put this piece in there as well for purposes of appeal, or whatever the reason might be. So we'll let you know either way sometime soon, and we'll try to keep this case moving. Mr. Sears, anything else on behalf of Ms. Smith?
I believe that covers it, Judge.
Ms. Gibson, anything else on behalf of Ms. Montgomery?
No.
All right, thank you both. You'll take care of the court reporter?
Yes.
Great. All right, court reporter, do you need anything from either of these lawyers at this time, or you know how to track them down?
I do, Your Honor. Thank you, sir.
All right, thanks everyone. Have a
Thank you,
great
Your Honor.
day.
Have a good week.